Hello, YouTube. So I just wanted to make a quick video here and just discuss briefly some things to think about in the event that you are contacted for a DUI investigation. I've practiced, just a little bit of background about me. I've practiced for about 10 years in Washington State. Vast majority of that practice I have focused on criminal defense. Obviously, DUIs are a case that come up quite often here in Washington State in misdemeanor court. In Washington State, we're separating the superior and district courts. DUIs are typically handled in district court unless it's a felony type DUI, which would be based on how many prior convictions you have. Generally speaking, DUI contacts could occur in a number of ways. So it could be just from a random running of your plate and your information that shows a suspended owner in Washington State. If an officer runs your plates and those plates are tied to an owner who has a suspended driving status, that's a valid basis to stop here in Washington State. A lot of times you'll see DUIs start from that context where it was initially a investigation for a driver on a suspended license. At the contact at the window, the officer then immediately notices an odor of intoxicants, and then it moves into a DUI investigation. The other route would be lane travel, speed, how you're driving, right? Driving with your lights off at night, right? These are all things that are going to draw attention with police. And obviously you're going to keep police in that this could be a potential DUI investigation. When you are contacted by law enforcement, at least here in Washington State, you are required to provide certain information: your driver's license, your registration, your insurance information. All this is required by statute to be given to law enforcement. However, you are not required to provide any other information. Typically, officers are going to ask you questions. You do not need to answer those questions. If an officer does ask you questions, you can politely decline to answer those questions. For example, you can just tell them that you do not wish to discuss your day or your evening with them, but whatever you're required to give them, you'd be happy to comply with that and just keep it short and sweet. The obvious question that officers like to ask is, have you been drinking tonight? To which most people, from my experience, tend to respond with something like, yeah, I've had a couple beers, or I've had 3 or 1. Any admission that you have with respect to drinking is not a good thing. 1 beer is not a good thing. 2 beers is not a good thing. Okay, so like I said, answering questions, no. That's not what your job is to make their job easier, which is what you're doing when you're answering questions at the side of the road. Now, what you could do at the contact is you could ask the officer whether you're free to leave, whether you're being detained, or you're free to go on your way. This kind of puts the ball back in the officer's court, and the officer at that point, more than likely, if, for instance, it's a lane travel issue and speed, the officer, just based on your driving, is highly suspicious of the fact that you are DUI and stops you for that basis. And then when he contacts you at the window, you reek of alcohol. At this point, he has probable cause to arrest you. Okay, so any statements that you provide to him are simply going to be used against you in court. They are not beneficial. Now, in Washington State, they will also ask you if you wish to perform SFSTs, which are standardized field sobriety tests. These are voluntary. Now, a lot of times officers aren't very clear with the individual contacted that those are voluntary tests, but they are in fact voluntary in Washington State. My recommendation is that you do not volunteer to do those tests. In fact, I have one example I'll share with you. I was in a COE and witnessed another attorney go through these standardized field sobriety tests that were administered by an ex-law enforcement officer, and that individual failed those tests. Now, I would hope that that individual was not drinking before coming to the COE, and I'm pretty certain that he wasn't. Nonetheless, he failed that test. They're what I would call multiple distraction tests. They are meant to focus you in on your ability to understand instructions as well as do physical activities. And if you miss either one of those, obviously that's going to count against you. And most people don't get it right, even if they are clear-minded and sober. So you wouldn't want to volunteer for those tests necessarily, because it's just building a case against you. In a lot of situations, at the point at which they're asking for SFSTs, in their mind, they have already developed probable cause to make an arrest, and they're simply padding the case for the prosecutor. The other thing that they may ask you to do, at least here in Washington State, is to take a PBT, which is a portable breath test. In Washington State, a PBT test is also voluntary. Now, the officers here will be a lot more clear that this is a voluntary test. You do not need to take this test. This test is not a replacement for the breath test down at the station or a blood test. And so again, you'd want to decline this test because it's simply just building that case against you from the perspective of the prosecutor, right? And we don't want to do their job for them, make them earn it. And so you would decline this test. Now, at this point, the officer probably already has probable cause based on his observations of you and your intoxication, odor of intoxication, bloodshot, watery eyes. When he asks you to step out of the vehicle, he's probably going to note in his report that you stumbled, were unsteady on your feet, had to hold onto the car for balance. These are all common things that you see in the report that an officer uses to build probable cause. And so at that point, you're more than likely to be arrested, okay? They're going to handcuff you. Obviously, this is a scary part of the process. But again, we want to remember that we're not answering questions. We're not volunteering information. When you go through the booking process at jail, right, you want to provide certain biographical information. That makes sense. Things that aren't going to hurt your case. What's your name, right? Provide your name, date of birth, address, things like that, height, weight, but nothing more, all right? No discussion of the case, no discussion of what you might have had to drink that night or anything like that. Now, in Washington State, there's what's called informed consent for breath and breath test. And what they'll do is they'll run you through a sheet, and they'll describe to you that while the PBT test is voluntary, the test at the office or at the Washington State Patrol office or at the Sheriff's Department or Police Department, wherever they may have taken you to book you in, they'll have what's called a Draeger Alco test 9510. And that test is required to be taken. Now, if you refuse that test, at least here in Washington State, that has negative impacts on your case. It also has negative impacts on your license status. So if you refuse that test, the fact of your refusal can be referred to at trial. Typically, something like that is, it kind of falls under the rubric of, well, is that testimonial? The courts have come down and said, no, it's not a testimonial statement to refuse the test. But it can be referred to as evidence of your guilt. Obviously, that's not a good thing. If you refuse the test, they'll also indicate to you that your license will be suspended for a period of 1 year, as opposed to the initial 90-day suspension that you get here in Washington State. So those things, bearing those things in mind, you may want to take that test. You also have a right to an independent test. You also have a right to have blood work done, which are things that you can do. Now, the officer may, depending on the type of the DUI, move straight for a blood test. This would be in the case where he's not noting things that are indicative of alcohol. He's noting things that are indicative of possible narcotic use. There is kind of a fine line here. I would say in the event that maybe there are other things in your system, then it may benefit you to take that breath test as opposed to a blood test, even though the blood test is more accurate, certainly on the point of alcohol and other substances. If, for instance, you were a daily marijuana user and you're also drunk or have consumed some alcohol, then that breath test will pick up that alcohol. It's not going to pick up the THC, but if you take a blood test, it is going to pick up the THC. And so now you're going to have kind of a double whammy against you. You're going to have 2 strikes already. So you want to bear that in mind as well. If, it's just alcohol involved, it may benefit you actually to take the blood test as opposed to a breath test. In any event, you need to be aware that if you do refuse the breath test, that blood test is not offered, that's going to impact your license. It's going to be a fact that they refer to at trial, and those are negative things that you want to certainly consider. If you have any more specific questions on your specific DUI case, certainly you'd want to contact an attorney of your choosing at the earliest opportunity. Okay, don't wait on that. Get a head start on it and do it quickly. Contact an attorney that can help you out on your case and walk you through that process. You don't want to go it alone. And lastly, I would say that the advice or the comments in this video are not legal advice. They're simply hypothetical discussions based on the experience that I've had as an attorney here in Washington State. The discussion is also limited then to the law of Washington State, an area where I practice, but many of these laws are similar in other states. So if you are in another state, I would encourage you to at least be aware of the issues around your license and refusing a breath test, whether that impacts the suspension cycle, whether that's a fact, for instance, that they could refer to at trial like they can here in Washington State, right? These are distinctions that you're going to see in other states. Maybe they're not present, maybe they are. And if you have questions about that, obviously you'd want to contact an attorney. I hope this video was helpful to at least some of you out there. In the event that you do have a DUI contact, hopefully you'll be better armed to fight your case. Have a good day. God bless.